One of the most trenchant analyses of the modern relevance of champerty comes from North Dakota. In a 1970 decision, the North Dakota Supreme Court explained why the principle of champerty simply has never had any application in the context of American law, and certainly not in the context of modern American law. This analysis suggests an effective approach for responding to the arguments that litigation finance will prompt unmeritorious cases or discourage reasonable settlements. In Interstate Collection Agency versus Kuntz, the owner of a coffee shop owed a trade debt to a grocery store. When the grocery store failed in repeated efforts to collect the debt, it assigned its accounts receivable to a collection agency which sued the coffee shop in its own name. The coffee shop argued the collection agency could not have the right to sue on the grocery store's claim because the assignment of the claim violated the doctrine of champerty. The North Dakota Supreme Court began its analysis by quoting a 1916 case which explained the best reason for doing away with the doctrine of champerty: that the peculiar conditions of society which gave rise to the doctrine do not exist in this country. As the court indicates, the doctrine of champerty was developed to prevent wealthy feudal lords from abusing the legal system by sponsoring lawsuits against their enemies or rivals. In many cases, these lawsuits had no real merit or did not implicate interests that were important to the nominal plaintiff. They were pursued only as a form of harassment. Of course, in the United States, there has never been a class of aristocrats who were in a position to compel or persuade lower status individuals into filing groundless lawsuits. The Kuntz and Rohan decisions make a point about champerty that is almost always overlooked: that it was created to solve a problem that simply has not existed and could never exist in a country without a formal social hierarchy. When opponents of litigation finance identify the evils of investment in lawsuits, they adopt a version of this inappropriate historical argument. That is, they contend that badly motivated third parties will use litigation finance as an instrument to manipulate the legal process for illegitimate purposes. But there is no reason to think that this ever actually happens in the modern American legal system. Investment in lawsuits is driven by rational economic calculations, not by feudal rivalry. Litigation funders don't support cases unless those cases have a legitimate basis and a real prospect of success. In addition, litigation funders don't compel the parties they fund to persist in a case and reject settlement offers that are economically reasonable. They simply have no incentive for such irrational behavior. At their foundation, these arguments about litigation financing and lawsuit abuse are based upon a type of behavior that was unique to a particular time and place and that ended centuries ago. Just as America has moved beyond aristocracy, it is time to move beyond these outmoded arguments about litigation finance. If you need help with litigation funding, call or email me today.